Hello, students. Welcome back to class. Today, we're going to be talking about civil liberties and civil liberties in chapter 4 and chapter 5. Civil rights are very important because we hear these terms, but quite often they're conflated or they're used interchangeably. And it's really important to understand the difference between the two because they are very important concepts, but they are very different. So by the end of this video and by the time you're done reading chapters 4 and 5, you'll have a clear understanding of what are civil liberties, what are civil rights, and the difference between the two. And so the first thing I'm going to talk about is civil liberties, and then I'll contrast that with civil rights. And when you read the civil rights chapter, as you should be doing now, getting ready for your quiz, this should be very clear to you. Okay, so civil liberties. Civil liberties deal with rights that you're born with. If you look back at our founding documents, our Declaration of Independence, our Constitution, we see these in a lot of state constitutions. We talk about these constitutional provisions, these clauses. They're focused on the individual and the rights of the individual. So the framers, the founders saw the freedoms that we have, the freedoms that we cherish are natural, right? We're born with them. They're God-given. And so these are things that the government can't take away. God's given to them, or you were born with them. However you want to look at it, the government can't take them away because they're inherent. They're rights that we have. So what are we talking about, right? So if you're born with these freedoms, right? Think of freedoms. Every time you think your civil liberties, I want you to think freedom. So if we have these freedoms, civil liberties address issues or freedoms that the government cannot infringe upon, right? They're placing limits on what the government cannot do. So you think civil liberties, I want you to think freedoms, I want you to think natural, I want you to think God-given, and I want you to think about what the government can't do. Civil liberties address limits on the government. Okay. Now let's contrast that to civil rights, because we hear that all the time. I have civil rights, I know my civil rights, I have freedom of speech, freedom of religion. You hear that. But civil rights don't address, our civil rights aren't about freedom of speech, freedom of the press, freedom of religion. Those are civil liberties, right? And we'll get into some of those details. What civil rights are things the government must do to ensure that everybody is being treated fairly, right? So civil liberties are the things government can't do, the things that they cannot do to infringe on your liberty. Civil rights, if the government is acting constitutionally, are things that if they create a statute or they create a regulation, the civil rights are things that they must do to ensure that every individual, every group of people is being treated fairly. So as we'll see more in chapter 5, and we'll discuss that, what are we talking about, right? We're talking about the right to vote, the right to access education, right? So if, let's say in our history, where white citizens were allowed to vote and Black citizens were not, that is a violation of civil rights because individuals are not being treated fairly under the law. Everyone should, that meets certain basic requirements. And when we say basic requirements, we're talking about meeting a certain age, right? Typically 18, and they have citizenship. Beyond that, typically, if you meet those two requirements, you should be able to vote. And if laws or those in a official government position are preventing different individuals that meet those requirements from accessing the ballot box or accessing education, then civil rights violations have been committed. So really important, civil rights are things that the government must do to ensure that everybody is treated equally and fairly under the law, right? That's a really important concept in our founding documents, these founding values of rule of law, the importance of the rule of law and following the rule of law and making sure that everyone is treated and seen fairly under the law, right? So we're going to go back to civil liberties, right? The things that the government can't do, right? Civil rights, things the government must do. Civil liberties are what they can't do. So what are we talking about, right? We're talking about typically the Bill of Rights. Now I know this gets confusing because right in the phrase there, Bill of Rights, we're talking about civil liberties. So try to keep that clear in your mind. I know it gets confusing, but think of the Bill of Rights as the Bill of Limits, right? Limits on, not on us, not as citizens, but limits on the government, okay? So think Bill of Limits, civil liberties, God-given freedom. And that's very important when it comes to civil liberties. So this is typically what people talk about when they are maybe saying civil rights, right? We don't hear civil liberties used a lot of time. We hear freedom, the words freedom and civil rights kind of used interchangeably, but right, when we're talking about things like the First Amendment, our First Amendment rights, right? We use that word rights again, right? Get that out of your mind. Our First Amendment freedoms, use that, our First Amendment freedoms, because this addresses things that, again, the government can't do. So what are those, right? So we talk about the freedom of religion, the ability to practice your religion, right? There are, again, some limits that you'll read about and we can have discussions about, but the fact that you can practice your religion the way you see fit is very important. The government can't come in and tell you that, no, this is not a religion that you can't practice. These aren't rituals that you can do, right? If rituals impact public health, those are different. Those things are different because now you're impacting others. But by and large, your religious freedom, the things that you practice, your different religious rituals, the government can't come in and say, no, these are not allowed in the United States. No, remember, government cannot come in and do that, right? And that's very important. Now, we'll talk about a few of these freedoms, right, in the Bill of Limits. But I want to talk really briefly about this at the founding, right? During the ratification process to the U.S. Constitution, there was this debate about whether or not, like the fact that the Constitution, there was those that argued that the Constitution didn't identify any of these freedoms in the document, right? And there's folks, the anti-federalists, primarily pushing back and saying, look, we cannot ratify this document because there's no freedoms that are laid out in the constitutional document anywhere. Nowhere does it mention freedom of the press, freedom of speech, freedom of religion, the right to defend yourself, talking about the Second Amendment, right? The fact that you should be secure in your own home, free of unreasonable search and seizure, right? You should have the right to an attorney, a speedy trial, all of these things that we see in the Bill of Limits. The anti-federalists were saying that it doesn't mention this anywhere. And so the pushback was that we're not going to ratify this document at the state level until those provisions, or at least this agreement was made that the Bill of Limits was placed on the Constitution. So a deal was struck, right? So essentially the general deal was ratify the Constitution, and the first action that will be taken will be the Bill of Limits that outlines what these freedoms are. The Federalists were arguing that this is dangerous. To put a list, a physical list in the Constitution was dangerous because that might be construed as a complete list, right? And anything that can't be found in the Bill of Limits will be seen as will be seen as a liberty, as a freedom that citizens do not have, right? And so during this discussion, we ultimately get the Bill of Limits after the Constitution was ratified, and the Ninth Amendment addressed that concern. The Ninth Amendment generally states that basically says the Bill of Limits is not a complete list of rights that citizens have. Okay, so the framers were trying to address all of these concerns, right? To the Federalist argument was having the separation of powers, right? Because the anti-federalists were saying, right, we're fearful that the central government will get too strong, right? So that's why we need this list to be able to point to. The Federalists were saying, well, number one, be fearful, be concerned about a list, because if it's not a complete list, there might be problems. But number two, they were arguing that the separation of powers at the national level, plus the checks and balances, would be sufficient to prevent a tyrannical government. Ultimately, the anti-federalist argument won out. After the Constitution was ratified, the first 10 amendments to the Constitution were ratified as well. We call those the Bill of Rights. Again, think of those as the Bill of Limits. That's very important. And those are the freedoms that we point to today. Obviously, some more than others, right? The First Amendment, right? There's a reason it's the First Amendment, because those are top of mind to the framers and what was of concern to the framers at the time. So we think about the First Amendment, the freedom of religion. And we have to think about the Establishment Clause. Again, the Establishment Clause prevents the government from establishing a national religion. Again, what the government can't do. The Free Exercise Clause, okay, what the government cannot do to infringe on your ability to practice your religion. And things like this, these issues of freedom of religion have come into play and still come into play when it relates to school vouchers, any public funds being used in religious institutions to provide even secular education for those with disabilities, or maybe for secular field trips or math, science books, right? This debate has gone on in the courts about what constitutes a violation of the Establishment Clause and how much government and the private religious institutions can entangle themselves. So the courts have wrestled with this, and they've erred on the side over time. They've erred on the side of allowing, in certain instances, public funds to go to religious institutions, providing that those funds were used for secular purposes. Right? So we talk about not just religious freedom, right? But religious, we talk about religious speech. And we've seen this used there's an important case, Rosenberger versus University of Virginia, when it talks about student group funding. Okay, and at this case, a religious group, a religious student group, they qualified as a student group, but when the school funds came out, right, the rules were that you would get a certain amount of funding for a student group if you indeed were a student group. Well, the university said, well, we can't give funding to you because we're a public university and you're a religious group. Well, the courts have said, no, that's now you're violating that group's free exercise rights or freedoms, right? So now you're preventing them. You're saying that is a reason to prevent them from receiving funding, right? So that's a violation. So the courts have tried to strike this balance between the Free Exercise Clause, right, and the Establishment Clause. And they said, if you're treating a religious group differently than you would any other group, you're discriminating against them, right? You can't discriminate against that group simply because they're religious. If you treat every other group a certain way, you can't treat a religious group different just because they are a religious group. That doesn't constitute, a violation of the Establishment Clause. You just treat every group the same. You can't single out religious institutions. Okay. So again, any type of freedom of religion, freedom of expression, right? And in freedom of expression, we include symbolic speech, right? The burning of the flag, which has been ruled to be constitutional. The fact that we have to allow even things that we might not like, we don't want to see, right? We have to allow, if we want to really recognize these freedoms that we have to allow even things that we disagree with to be said, to be done, again, assuming they don't infringe on other people's freedoms, okay? All right, so I want to talk just briefly about the Second Amendment, and then we'll talk a little bit about the Third, Fourth Amendment and the rights of the accused, because these are really important. Then we'll wrap up. And then I'm going to have another video about incorporation theory and how that relates to the Constitution being applied to state action. All right, so the Second Amendment, this is really important to talk about because the debate surrounding the Second Amendment is, I think, a lot of times misunderstood. Right? We get wrapped up in this conversation about mass shootings and gun violence, gang violence, and people, there's a group of folks or individuals that say, we need to do something. We want to prevent this crime from happening again. I think that's purely natural. And of course, we want to prevent these things from happening. And what gets wrapped up in this debate is, always the Second Amendment, and what the Second Amendment means, what it should mean, how it should be applied. And so we have this debate about, what we should be able to do or how we should be able to regulate guns under the Second Amendment. So I kind of want to break down the argument in simple terms and then help you kind of understand where a large chunk of the population stands on one side or the other. Okay, so the Second Amendment is broken up into two clauses, right? The prefatory clause and the operative clause. Those that favor, and these are just, I'm just having a general discussion about this. This isn't, these aren't universal, but generally, those that argue in favor of more gun regulation, right? They focus on the prefatory clause. Okay, so let me read the Second Amendment, right? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. All right, so the first part of that amendment, a well-regulated militia being necessary to the security of a free state, that's the prefatory clause, right? That's the preface in which the amendment stands. Okay, so you're basically saying, right, this is why you need the Second Amendment, making the argument for the Second Amendment, the preface. Okay? The operative clause, where the civil liberty, and this is where the courts have ultimately come down in McDonald and Heller, is that the operative clause identifies the individual freedom in which the government can infringe upon, right? So the operative clause says the right of the people to keep and bear arms shall not be infringed. Okay? And the courts have ruled that that identifies clearly the individual freedom outlined in the Second Amendment, right? So in the prefatory clause, individuals talk about language of a well-regulated militia, talking about the military. And that's where the argument generally comes down. And it relates to what the government can't do, right? The government has the right to regulate a militia, right? If you mean a military. So this is a civil liberty that deals with government action, right? Well, and then the other side argues, well, this runs counter to this idea of limiting what government can't do, right? And so you have this battle based on language within the Second Amendment. So I just want you to understand that, because that's really important. So hopefully you have a better understanding, because of those two clauses, where those on either side of the argument kind of root their arguments. Okay? All right, so Third and Fourth Amendment, right? We've third isn't heard of too much. We don't really discuss that, but it's about quartering troops without permission from the homeowners, right? Goes back to this idea that you have property, right? You have the freedom to have life, liberty, and property, right? Your property is yours. You get to do with your property what you like, right? The government can't come in and take over your property. Talk about the Fourth Amendment, unreasonable searches and seizures, right? This puts the pressure on the government, right? The government has a responsibility to investigate crime, but they have to do it in a certain way to protect the freedoms of the individuals. So government has to have a reason to search your property, right? They can't just come in and do it whenever they want to see if there's a crime, right? They have to have a reason. They have to go before a judge. They have to make their case, right? They have to have probable cause, and the judge has to rule on that. And even after the judge rules on that, it can be ruled subsequently in appeals courts and say, well, even though it was ruled, the search warrant was issued, it shouldn't have been. There wasn't probable cause, right? So these can be argued, right? And there's checks and balances within the court system, appellate systems, right? Throughout, right? All of these checks and balances that err on the side of the accused, right? You have the Fourth, the Fifth, the Sixth Amendment, right? You have a right to a jury of your peers, right? You have a right to a speedy trial. You have the right not to incriminate yourself, right? These are all designed to protect the individual from a overpowering or overburdening government, right? Because these are things that the government, right? They basically places hurdles in the way of the government to err on the side of protecting the individual, right? All right, so one component, and I think it's important to talk, and you've read that sometimes these civil liberties, they compete, right? You have like freedom of religion, but you compete with public health, right? If you have a religious practice that can violate public health and make other people sick, right? You can't do these things. So there's competing interests. And one of the competing interests when it comes to civil liberties is this idea of the rights of the accused and the right of individuals to a fair trial and the right to a free press, right? The freedom of press and the freedom of press in the courtroom to cover stories that news outlets deem desirable to cover and report on. So in some circumstances, the courts have to always balance these two important civil liberties. And what they've sometimes erred on is the side of the accused and issued gag orders, right? The fact that the press can't be in the courtroom, the press can't report on certain cases or aspects of the case because that would prevent an individual from getting a fair trial. So these civil liberties don't operate in a vacuum. They don't exist in a vacuum. So sometimes they're competing, and the courts have tried to figure out how they can work together. And if you're going to rule on one side or the other, what side do you rule on? Right? And in this particular case, gag orders, they rule on the side of the accused. Okay, so and then other cases such as Miranda v. Arizona, right? This idea of when you have to know, we hear of Miranda rights, right? That came from an actual case where the courts have decided that no, you have to notify people of their constitutional rights, right? That could be a burden for government because once you notify someone that they have a right to an attorney, they might stop talking or get an attorney, and you might not have a free, open discussion, or you might not be able to pressure them into a confession, right? Which is what was accused in this case. So the police officers, prosecutors, they have to make sure that these individuals' Miranda rights are not being violated, right? People are notified of their Miranda rights, their Miranda freedoms before any discussions, any interviews or interrogations can take place. So again, think about this. Every time the government has limits placed on it, the courts have ruled on these cases, and this is where we get a better understanding of how civil liberties operate in our society by how the courts have ruled, and that's evolved over time, and the courts have sorted out these issues, and we'll see that a lot in civil rights as well. But hopefully now you have a better understanding of civil liberties, and we'll talk more about the civil rights, but hopefully you have a better understanding of that as well. And watch the next video about incorporation theory, and you have a great day. We'll see you next time.